Hi everybody. Today we'll see about introduction of the partnership. So welcome to this video session. So what is a partnership? So partnership is a relationship between persons who have agreed to share the profits of a business. So for forming a partnership, you need a minimum of 2 members, the maximum of 100 members. So section 4 para 1, persons who have entered into a partnership with one another is called individually as partners and collectively as a firm. This is according to the section 4 para 2. So partnership is based on an agreement. So the partnership agreement may be made orally or in written and may be implied from the course of dealing among the partners. So when 2 or more persons join together and they enter into a partnership, so you can infer that they are doing certain business. However, all the essential elements of the valid contract must be present for a partnership. So if the valid aspects of the contract is not there, the partnership is not a valid one. There must be free and genuine consent of all the parties who must be competent for the contract. So the persons who are entering into the contract, they must have the free consent to join for the business. If somebody is forcing them to enter into a partnership, that cannot be valid one. The object of the partnership should be lawful. The business in which you want to do should be lawful, legally enforceable. If you do anything illegally, that cannot be a valid one. And other legal formalities should be compiled with in the partnership. What are the legal formalities are there for doing the business, that has to be compiled with. But the following 2 points must be noted in this connection. That is, you should not enter into a contract with a minor partner, but sometimes they may be allowed to go for a minor partner also, but with the consent of all the members of other partners. And other point is consideration. Yes, no consideration is required to create an agency. According to the section 185 of the Indian Contract Act 1872, no consideration is required to create a partnership, which is an extension of a law of agency. Let's see who may be the partners. The contract of partners may be entered into by every person who is competent to enter into the contract, section 1 of the Indian Contract Act 1872. Alien enemy cannot enter into a contract of partnership with an Indian subject. An alien friend can do so. For example, you cannot enter into a contract with an enemy country. If you are having a war with other country, they are called as enemy country. So you cannot enter a contract with an enemy country, that is an alien enemy. And then minor cannot become the partner of the firm, but with the consent of all the members of the partners, they can be inducted into the partnership. Persons of unsound mind cannot enter into that. That means you cannot have a partnership with a person who is mentally unstable, who is not good in mentally. And you cannot have a partnership with corporations. That means a corporation, a registered company, can enter into a contract with a partnership as a single individual, but not as a group of individuals comprising it. So these are the persons can be entered into the partnership. Who cannot be the partners? According to the section 5 para 2, the following persons, in the addition to the already discussed points, are not partners. The first point is the members of the Hindu undivided family carrying on the family business. You cannot have them as a partners. And similarly, a Burmese Buddhist husband and a wife carrying on the business as such, they cannot become a partners. Let's see what are the different kinds of partners. Actual partner, a person who becomes a partner by an agreement and is actively engaged in the contract of the business of the partnership, is known as an actual partner. Then second type is sleeping partner. So there are certain persons who invest money into the business, but they will not participate actively into the business, they are called as sleeping partners. But normally when the persons are having more business, persons may come for this kind of agreement. So when all other members are accepting for this, then a person can become a sleeping partners. But profit, everything will be given to them, but they will not actively participate in the day-to-day affairs of the business. The next type is nominal partner, a partner who lends his name alone for business. That type of partners are called as nominal partners. Why this kind of person has to be inducted into the partnership? Because they may be reputed in the field, they may be known person in the field. So you are starting a business, so you are, for the namesake, you are taking them into your partnership so that they will have a good name that can be extracted for the business. And there are other partners who share only in profits. For example, a partner may agree for a partnership that shall get a share of profits only, and that of he will not be liable for any loss. If a business gives only profit, this partner will share the profit. At the same time, if the business ends up with any loss, this person will not share the liability, that is a loss. So that is a kind of partnership that is called as partners only in profits. Then there is another type of partners, they are called as sub-partners. When a partner agrees to share his promise derived from the firm with a third person, that type of third person are known as sub-partners. Then finally, a partner by estoppel or holding out. Sometimes a person who is not a partner in the firm may, under certain circumstances, be liable for debts as if they were a partner. Such a partner is called as partner by estoppel or holding out. Hope you have enjoyed this session on partnership. Thanks for watching.